The chair is authorized to declare a recess of the committee at any time. This hearing is titled Agency Audit, Reviewing CFPB Financial Reporting and Transparency. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. The CFPB is increasingly out of control and lacks transparency because there are virtually no checks on the agency's power. As the most recent example of the lack of transparency and accountability towards Congress, a request was made by this subcommittee for the CFPB to provide a witness for today's hearing, but the CFPB declined. While the GAO audits the CFPB's attestations about its financial condition, those audits have important caveats identifying that GAO is only monitoring numbers and not policy or budgeting decisions. Moreover, an additional independent audit is required by statute, but the CFPB does not seem to take this mandate seriously. The most recent audit was a mere 9 pages long and curiously contained 0 findings or recommendations, not independent. Due to this lack of oversight, the CFPB has acted unilaterally and arbitrarily outside of its statutory mandate, routinely without engaging in notice and comment rulemaking, and instead operating through rulemaking by guidance, press releases, or blog posts. Further, the agency has engaged in enforcement threats without adjudication. A rogue CFPB under Director Chopra is no help to consumers, even if advocates of the CFPB tout the amount of fines and damages awards the CFPB claims to have generated. The sanctions generated have costs, and they also come at the social cost of Director Chopra's blanket indictments of hardworking and honest workers throughout the financial system. These institutions play by the rules, help consumers, and provide fair financial services. Yet their reputations are unfairly tarnished through Director Chopra's portrayal of them as crooks who are out to take advantage of their fellow Americans. Courts have acted to strike down numerous CFPB unlawful actions under Director Chopra as he continues to far overstep what he views as unbounded authority and power. And courts must play that role partly because Congress has no ability to rein in the CFPB's overreach, puffery, and false statements through our own most effectual weapon, the power of the purse. The Supreme Court has the opportunity to confirm what Republicans have said all along. The CFPB's unaccountable funding structure is unconstitutional, and the agency must be brought under the appropriations process. Congress should act now to reassert the power of the purse and ensure unelected bureaucrats do not have the ability to run roughshod over the personal rights of consumers and law-abiding businesses. Through a design feature in the Dodd-Frank Act, the CFPB was purposely set up to insulate a government agency from proper congressional oversight. The CFPB was set up to ensure unbridled power for an authoritarian agency head who wants to exercise partisan and unreasoned control over financial services with the ultimate goal of turning financial institutions into public utilities. Unfortunately for consumers, the CFPB's policy actions under Director Chopra's leadership have become almost entirely reckless, arbitrary, and capricious. Pushing new rules, guidance, variable enforcement actions, blog posts, and email blasts that border on anti-capitalist propaganda does not promote consumer protection. The CFPB's activities under Director Chopra's leadership will serve primarily to increase costs of financial services to consumers and reduce availability of those services, especially to traditionally underserved communities. This is quite the opposite outcome of what you'd expect from an agency tasked with protecting consumers. The CFPB has increasingly become a hyper-partisan agency doing the bidding of the White House and the president's re-election campaign, rather than protecting American consumers. It answers to no one but itself, and sometimes to the courts, where the CFPB director's approach of using rhetoric and partisan theorizing over evidence and the law is often rejected. Where the administration does not have the authority or votes in Congress to make a change, the Bureau simply forges ahead and uses subterfuge to make new laws unchecked. I look forward to discussing these important issues in our hearing today. We must understand the consequences of a rogue CFPB and explore the steps Congress must take to rein in the CFPB to better protect our citizens from an unchecked federal bureaucracy. There must be guardrails on a rogue agency like the current CFPB, and that must at least begin with holding the CFPB's use of federal resources accountable, transparent, and subject to congressional checks. The chair now recognizes the ranking member of the Subcommittee on Financial Institutions and Monetary Policy, the gentleman from Illinois, Dr. Foster, for 4 minutes for an opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses here today. Since the Consumer Financial Protection Bureau opened its doors in 2011, it has served as the cop on the beat, protecting consumers from unfair, deceptive, and abusive practices and taking action against violators of consumer protection laws. The CFPB has provided more than $19 billion in relief to 195 million consumers and required financial firms who have broken the law to deposit more than $4.8 billion in the Victims Relief Fund, which is used to compensate consumers who have been taken advantage of in the financial marketplace. Bipartisan polling has shown that the CFPB is overwhelmingly popular among U.S. consumers, finding that 82% of voters, including 77% of Republicans, support the CFPB's mission. So it's right up there with IVF. So today we will discuss the CFPB's budget process, and I expect that we will hear the same decade-old arguments that in carrying out its mission to protect consumers, the Bureau and its budget have somehow gone rogue to the detriment of American consumers. I believe that we can dispel this notion by looking at the facts. Like other independent agencies, the CFPB's budgetary process is subject to intense and independent scrutiny. The CFPB's annual budget is submitted to multiple independent entities for review, including the Government Accountability Office and independent auditors. The result of these reviews have overwhelmingly affirmed the soundness of the CFPB's budget, with the Bureau receiving a, quote, clean, unquote, audit opinion with limited findings over the last 13 years. The CFPB regularly publishes comprehensive financial and performance reports, including quarterly spending reports, annual performance plans, as well as monthly reports to the Treasury and GAO on its financial activities, including contract spending. In addition, the CFPB director is statutorily required to testify before Congress twice per year to discuss the activities of the Bureau, its budget, and other topics to allow the committee to provide robust oversight on its activities. The 2008 financial crisis showed that the disjointed consumer protection efforts of the agencies had fallen short, and that there was a clear need for an agency focused on protecting consumers in the financial marketplace. These lessons ultimately led our committee to create the CFPB through the Dodd-Frank Act, which I am proud to have helped draft. In addition to cracking down on inflationary and unnecessary junk fees, the Bureau is working to give consumers the ability to control their own financial data, curb discriminatory lending practices, and finalizing remaining rulemakings from Dodd-Frank. It is doing so while also being responsive to new risks stemming from emerging technologies like peer-to-peer payment applications and artificial intelligence. And despite its overwhelming popularity and many consumer protection successes, the CFPB has been under constant attack from those who wish to undermine its mission. The Supreme Court is set to rule on the constitutionality of the CFPB's funding mechanism as early as June of this year. A ruling against the CFPB would be massively disruptive and destructive to the Bureau's implementation of consumer protection laws and curtail protections that consumers expect and deserve. As members of this committee conduct oversight on the Bureau, I urge them to consider the progress that's been made since the 2008 financial crisis and ensure that additional oversight does not undermine its important mission that has spared countless consumers from harm in the financial marketplace. I look forward to hearing the perspective of our witnesses today, and thank you for joining us, and I yield back.
The gentleman yields back. The chair recognizes the ranking member of the committee, the gentlewoman from California, Ms. Waters, for 1 minute.
Thank you. Today, this subcommittee could have been examining ways to strengthen consumer protections with respect to predatory payday lending, debt collection, junk fees, and so much more. Instead, Republicans are here to continue their crusade to crush the Consumer Financial Protection Bureau. House Republicans revealed their true colors last year when 2/3 of their caucus voted to defund the CFPB, but thankfully, Democrats handily defeated that effort. Instead of doing the bidding of wealthy financial executives, Republicans should listen to their constituents. After all, 82% of Americans, including 77% of Republicans, support this popular agency because it is a strong, transparent, accountable agency, and it fights for them all. And Democrats will always protect the CFPB and the consumers they defend. Ladies and gentlemen, we got the CFPB as a result of the meltdown of 2008. I love it, and we're going to defend it every day.
Gentlelady's time has expired.
I yield back the balance of my time if I have any left. Thank you.
The gentlelady's time has expired. Today, we welcome the testimony Brian Johnson. Mr. Johnson is Managing Director at Potomac Global Partners and former Deputy Director of the Consumer Financial Protection Bureau. Welcome back to the committee, Mr. Johnson. Adam J. White. Mr. White is a Senior Fellow at the American Enterprise Institute and Co-Executive Director of the Antonin Scalia Law School's C. Boyden Gray Center for the Study of the Administrative State. And Christopher L. Peterson. Professor Peterson is the John J. Flynn Endowed Professor of Law at the University of Utah, S.J. Quinney College of Law. We thank each of you for taking time to be here. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony. Without objection, each of your written statements will be made part of the record. Mr. Johnson, you are now recognized for 5 minutes to give your oral remarks.
Chairman Barr, Ranking Member Foster, and members of the subcommittee, thank you for holding this important hearing on the CFPB's financial reporting and transparency. I'm Brian Johnson, Managing Director of Potomac Global Partners. I previously served as Deputy Director of the CFPB, and prior to that, I served as a member of...
Sorry, the gentleman will suspend. Members could please take their conversations off the committee so we can hear the witness. That would be appreciated. Mr. Johnson, you'll get your time back. You may proceed.
Thank you, Chairman. The Congress that created the CFPB and the Dodd-Frank Act designed it to be independent from both the President and Congress. It was meant to be independent from the President based on for-cause removal protection afforded to the Director. However, in 2020, the Supreme Court struck down this provision as unconstitutional. The Dodd-Frank Congress also made CFPB independent from itself through a novel funding source. Unlike most departments and agencies, the CFPB is not subject to the normal congressional appropriations process. Instead, it draws its funding from the Federal Reserve. The Supreme Court will soon decide whether this funding mechanism is also unconstitutional. No matter the outcome in the case, Congress must grapple with an extraordinary situation. What to do with an agency that now operates under the direct political control of the White House, but is not answerable to Congress for its funding. For that reason, today's hearing is timely. I would like to provide a general overview of how the CFPB obtains and expends its funds. First, any funds the CFPB draws from the Fed are not available to be remitted to the Treasury to reduce the deficit. And the CFPB is entitled to Fed funds even when, as now, the Fed is taking combined quarterly losses. Second, by law, CFPB's funds may not be reviewed by the Fed or by congressional appropriators, and the CFPB's budget is not subject to approval by OMB. CFPB's funds may not be considered government funds or appropriated monies. Third, CFPB's annual draws from the Fed are subject to a statutory cap indexed for inflation. For fiscal year 2024, the cap is projected to be $785 million. However, the CFPB can also carry forward unobligated amounts to future fiscal years. So the CFPB's total budgetary resources are projected to exceed $1 billion next fiscal year. Since fiscal year 2012, the CFPB's budgetary resources have grown at a compound annual growth rate of 7.7%, compared to the FTC's equivalent growth rate of 3.5%. Fourth, the CFPB estimates that its spending this fiscal year will reach $763 million, a 9.5% increase over last year. Almost 2/3 of this amount will be spent on staff salaries and benefits. CFPB now has about 1,700 employees who on average receive compensation of over $257,000 per employee, an amount that has grown at a compound rate of 5.8% since fiscal 12. By comparison, average FTC compensation is about $158,000 per employee and has grown at a 2.5% annual rate over the same period. CFPB employees receive generous benefits, the dollar value of which has grown more rapidly even than salaries. The CFPB is also in the midst of negotiations with its labor union and is expected to reach an agreement on additional automatic raises and bonuses that will bind the agency for the next several years. Fifth, regarding contract and support obligations, the CFPB has entered into interagency agreements for services at a cumulative cost exceeding $1 billion since fiscal 13. It also contracts with private sector entities, and while aspects of this spending are not transparent, some of its major spending categories are known, such as an initial obligation amounts for management consulting and program support services now exceeding a cumulative $250 million, as well as over $41 million for expert witness services. Sixth, oversight of these processes is minimal. There are GAO audits over CFPB's financial reporting controls, but not its spending decisions. And the FedIG has only twice directly reviewed the CFPB's budget and funding process. Dodd-Frank separately requires an annual independent audit of the CFPB's operations and budget, but the most recent audit report, only 9 pages long and with no findings or recommendations, is far from comprehensive. Thank you to the members of the subcommittee for engaging in much-needed oversight of the CFPB's funding and expenditures. I will be pleased to answer your questions.
Thank you. The next witness is Mr. White, and you are now recognized for 5 minutes to give your oral remarks.
Thank you. Chairman Barr, Ranking Member Foster, and members of the subcommittee, thank you for the opportunity to testify. My opening statement will be brief, I hope. I simply want to make 3 key points. My first point is this: the Constitution's power of the purse is one of Congress's most significant powers and responsibilities. The crucial provision of Article 1, Section 9 of the Constitution reads, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law." This was, at its very beginning, a crucial provision. James Madison recognized it. I described this in my written testimony. Other founders did too. They understood the power of the purse's fundamental role in constraining executive power. That's why it was the subject of such fierce debate in the first Congress and every Congress thereafter. And as the scope of government has grown over 2 centuries, so has the importance of the appropriations process. Even today, the Administrative Procedure Act and White House executive orders are important checks and balances on administration and mechanisms for oversight, but they are no substitute for Congress's constitutional power and responsibility. Indeed, now that the CFPB's connection to the White House is clear in the aftermath of the Supreme Court SELA decision, now that the CFPB is closely tied to the White House both legally and politically, this makes Congress's independent power and responsibility even more important. My second point is this: there is no good reason to give the CFPB its special exemption from Congress's appropriation process and responsibility. The CFPB truly is exceptional. To be sure, other agencies, especially other financial regulators, do receive revenues from the agency's own operations. This is a long-standing practice and in many ways a sensible one. But to the best of my knowledge, no regulatory agency is allowed to simply reach into a completely different source of federal money to be the agency's main source of revenue. No other agency gets to treat the Federal Reserve as a regulatory slush fund. The CFPB is, to the best of my knowledge, the first such agency, though I do worry it will not be the last. If the Supreme Court does not declare the CFPB's funding structure unconstitutional in the pending case, there will be many calls in the future to give other agencies special access to the Federal Reserve's funds. In fact, I recall in 2010 when the Dodd-Frank Act was first legislated and enacted, the chairman and chairwomen of other financial regulators, including the CFTC and the SEC, publicly called for similar funding authority, self-funding authority from Congress. So this is my last point. Speaking of the Supreme Court case, the CFPB's characterization of its finances in the Supreme Court case has been astonishingly at odds with more than a decade of the agency's own reports and descriptions. The Dodd-Frank Act itself stated explicitly that the CFPB's funds are not appropriated. And from the very start, the CFPB admitted this obvious fact that its funds are not appropriated, beginning with at least with its 2013 first financial report, Director Cordray's testimony before this committee's Subcommittee on Oversight and Investigations in 2012. And every year thereafter, the CFPB said over and over again that its funds were not appropriated. In fact, the CFPB trumpeted this fact to reiterate the agency's independence. It would often say that non-appropriated funding gave the agency, quote, full independence, end quote. It told the GAO in a 2016 contracting dispute that the GAO lacked jurisdiction over the agency because the agency's funds are not appropriated. But in the Supreme Court case now pending, the CFPB now makes the opposite argument, the novel argument that the Dodd-Frank Act itself was an appropriations statute. That argument strains credulity, it strains the Constitution, and it is the latest reminder that the CFPB should not enjoy exceptional powers against oversight. The power of the purse, the Constitution's power of the purse, and the responsibility to use it wisely remains Congress's. Thank you again for the opportunity to testify and for the chance to answer your questions.
Thank you. Professor Peterson, you're now recognized.
Chairman Barr, Ranking Member Foster, and Ranking Member of the Committee Waters, it's an honor to appear today. Thank you for your public service. My name is Chris Peterson. I'm the John Flynn Endowed Professor of Law at the University of Utah in Salt Lake City, where I teach consumer protection, constitutional law, and contract law classes. I'm also of counsel at the public interest law firm of Gupta Wessler here in Washington, D.C., and I served at the CFPB in the Enforcement Office and later as a special advisor to the director of the agency back under Director Cordray. Today I'll focus on 3 points. The first, the statute funding the Consumer Financial Protection Bureau is a constitutional exercise of Congress's spending power. Article 1, Section 9, Clause 7, as my friend mentioned a moment ago, says that no money shall be drawn from the Treasury but in consequence of appropriations made by law. The Supreme Court has held that that sentence says that it's simply no money can be paid out of the Treasury unless it's been appropriated by an act of Congress. And Section 12 U.S.C. 5497 is a law adopted by Congress that appropriates funds. The fact that this law appropriated funds through an ongoing mechanism does not render the law unconstitutional. The General Appropriations Clause does not require Congress to use an annual spending bill. As a result, Article 1, Section 8, Clause 12, in contrast, says that no appropriation of money to raise or support an army shall be longer than for a term of 2 years. Contrast the two, and you can see that the founders knew how to require durationally limited congressional appropriations, but made a conscious decision to not impose that durational limit on the general appropriations power. And as a result, Congress has often chosen to pass laws appropriating funding to executive agencies outside the annual spending bill process. For example, in 1792, Congress did that with the post office, allowed the post office to be funded through assessments, stamps, and it's not just the post office. In the founding era, the First Bank of the United States, the National Mint, the Patent Office, and the Comptroller of the Currency by 1875 were all appropriated through mechanisms outside of annual spending bills. And in the 20th century, that's become the norm for financial regulatory agencies, including, of course, the Federal Reserve Board of Governors, the Federal Deposit Insurance Corporation, the National Credit Union Administration, the Farm Credit Administration, and the Federal Housing Finance Agency, as well as the Citizenship Immigration Services, the Customs Border Protection, and the Animal and Plant Health Inspection Services, all appropriated either in part or in entirety through non-spending bill mechanisms. And of course, at any time, Congress is free to exercise its power of the purse by simply amending the Bureau's appropriation statute. But as it stands, this method of appropriating is one that Congress is free to choose under our Constitution. 2, Title 10 of the Dodd-Frank Act requires the CFPB to prepare annual reports subject to GAO oversight. I did a good, careful review of that financial report as well as the GAO oversight audit, and the GAO found that the CFPB's financial statements were presented fairly in all material respects and in accord with the U.S. generally accepted accounting principles, had effective internal controls, and had no reportable non-compliance for the last fiscal year. I didn't identify anything out of the ordinary either. Of course, we'll all disagree about what political priorities should be, but the simple fact is that the staff at the CFPB lived up to their reporting obligations and are in compliance with the law. Third point, the CFPB has an admirable track record of accomplishments in protecting American consumers, including its recent amendments to the Card Act's late fee regulations. Since the financial crisis in 2008, we learned that financial products that don't work for consumers can destroy our national economy. And that's why Congress created the CFPB. And in doing so, it's now returned $19 billion in relief to nearly 200 million Americans who have been harmed by violations of the laws that Congress adopted. And not only that, they've also succeeded in modernizing our residential mortgage lending regulatory system, and they created a modern national consumer finance complaint intake portal that's staffed up to receive complaints from consumers in 180 different languages and forwards 25,000 complaints every month to financial services companies to help resolve disputes and help individual consumers improve their daily lives. Recently, the Bureau announced its new final Card Act implementing regulations that's going to require credit card late fees to be reasonable and proportional in the way that Congress had originally contemplated back in 2009. In recent years, credit card issuers have imposed $14.5 billion in late fees just in 2022 alone. On balance, I think that the CFPB is headed in a positive direction, and I welcome the committee's
Gentleman's
questions.
time has expired. Thank you, Professor. Now we will turn to member questions, and the chair now recognizes himself for 5 minutes for questioning. Mr. Johnson, let me start with you. We all agree that the CFPB is funded like no other agency in the federal bureaucracy. The Fifth Circuit Court of Appeals held that the Bureau's funding mechanism is unconstitutional as it is double insulated from the appropriations process since it's funded by the Federal Reserve, the operations of which are also financed outside of the traditional appropriations process. But here's what I want to take up, because this was hotly debated within the oral arguments in the court before the Supreme Court. The professor has made the argument, and he's made it well and echoed the counsel for the Bureau that, oh, wait a minute, there's plenty of analogs to the Bureau of permanent appropriations, of an ongoing funding mechanism, and these are perfectly constitutional structures. I would submit there is simply no analog in the history of our republic of this. This is different than the post office. This is different from the FHFA. This is different than the FDIC. This is fundamentally different than the OCC. I want you to tell me, do you agree with that? And if you do, why is the Bureau's structure different? I would submit it's different because you don't have a structure anywhere in the constellation of the bureaucracy any time in American history where you have an agency exempt from the appropriations process that has an independent stream of funding from another entity which is itself exempt from the appropriations process. No analog anywhere in the history of our country. What say you?
Thank you, Chairman. I would agree with you that the CFPB's structure as designed is unique in American history. The CFPB fundamentally has a market conduct regulation function, and if you look for other agencies across the government and the funding structures that Congress has created for market conduct regulators, like the CFTC or like the SEC, those are all agencies that are subject to congressional appropriations. So the CFPB is unlike its sister regulators. It is not a prudential regulator. It's not like the OCC. It's not like the Fed. It's not like the NCUA. It's not like the FDIC. So among the independent financial regulatory agencies that Congress has seen fit to create, it is of a structure that is completely unique. It's additionally unique after the Saylor Law decision, where the director now serves at the pleasure of the president and so is subject to direct political control from the White House.
Mr. White, I want to follow up Mr. Johnson's last point there. Saylor Law corrected a constitutional infirmity and made the Bureau accountable to the executive branch. how would the symmetry of the separation of powers be served or not served if the Supreme Court were to not provide Congress with an additional check on the Bureau, similar to what it provided to the executive branch by subjecting the Bureau to the congressional appropriations process? Would that create an asymmetry of accountability to the White House post-Celia, but no accountability to the Congress without congressional appropriations?
I agree. These dual problems, these constitutional flaws were evident from the start. The Supreme Court has corrected the first problem with regard to executive power. I hope it corrects the second with regard to Congress's power and responsibility.
And Mr. White, would you discuss some of the drawbacks of agency structures that insulate the agency from congressional accountability, such as an agency whose budget is not set through the congressional authorization and appropriations? The professor talks about how they prepare reports to Congress. Is that enough?
It's not enough, sir. The appropriations process is important in and of itself as the way that our nation helps settle on its collective value judgments about what government should and should not be doing. But second, the appropriations process is Congress's tool for making sure that the rest of its constitutional powers over the agencies are obeyed.
You know, I've heard this argument that, well, Dodd-Frank, the Congress set this mechanism into place, and Dodd-Frank was an appropriation, and so therefore, voila, Congress has satisfied the appropriations clause. I did not vote for Dodd-Frank. I have never been able to vote for an appropriation that is meaningful. And by the way, to the ranking member, I voted to fund the agency to assert the power of the purse in the amendment process, but that failed. The TABS Act is not law right now. One final point to Mr. Johnson. Justice Kavanaugh says that, well, future Congress, in the oral argument says, well, future Congress could correct this. What say you to Justice Kavanaugh about that? Does just the fact that Congress could pass a bill in the future remedy an existing constitutional defect?
I don't know that it would, Chairman. The larger point, I think, is that it's profoundly anti-democratic to sever the people away from the way in which their funds collected by their government are spent by their government.
My time has expired. The ranking member is now recognized for 5 minutes.
Thank you. Professor Peterson, first off, just for clarity, the Federal Reserve, FDIC, OCC, NCUA, and other agencies have independent funding outside of annual appropriations, correct? All right, and so that a distinction appears to be made by those attacking the CFPB that insulation is okay, but double insulation is not. Is there a constitutional principle that differentiates between single insulation and double insulation?
Dr. Foster, no, I don't think so. I think that that's a red herring. And part of the reason you can tell that is that the Federal Reserve Board of Governors doesn't have any authority to deny transfer requests. So there's not a double insulation that provides some political insulation for the director of the CFPB nor the President of the United States. Congress has the ability to shut down those transfers anytime it can get the votes together to pass a law that changes it. Congress still has its power of the purse under the Article 1 of the Constitution because it can cut off these funds anytime it has the votes.
Now, you mentioned that you spent some time looking at the recent auditing that had been done. Can you say anything about it? Is just the indication that the final report doesn't span many pages, is that an indication there's anything wrong? And were there a reasonable number of man-hours going into these audits?
It appears to be just a typical report to me. I mean, Chairman Barr is correct that these reports don't tell us what the priorities of the agency are, but the executive branch of the government is entitled to make some decisions about how to prioritize things. The admirals get to decide where they're going to float the boats in the Navy, and the CFPB has to make some learned, informed decisions about the things to prioritize. The key thing that we can take away from the financial audit is that there's no evidence that there's anything inappropriate going on. And I think that's very important for the morale of the civil service and for the public to understand. There's no allegations of impropriety at the CFPB. Their books look like they are in order.
No, thank you. And Professor, in addition to your time working at the Bureau, you also spent a good deal of time at the Pentagon working in the Office of Legal Policy for Personnel and Readiness. As part of the Dodd-Frank Act, Congress established the Office of Service Member Affairs within the CFPB. so that special attention could be paid to the unique financial challenges facing U.S. service members, veterans, and their families. Now, through this office, the Bureau ensures compliance by financial firms with important consumer protection laws, like the Service Members Civil Relief Act, the Military Lending Act, and others. In fact, earlier this year, the CFPB announced that it would distribute nearly $6 million to veterans that had been targeted with predatory loans. So, given your experience at the CFPB and the Pentagon, would you expect that our service members and veterans would be worse off should proposals to undermine the agency be allowed to advance?
100%. You know, service members and veterans throughout history have often been the target of predatory loans, scams, and other cons and abuses, and we need a cop on the beat in Washington to try to make sure that they get a fair shake. They've served our country, and our country should serve them back by providing reasonable consumer protections and law enforcement that benefit their interests.
Yeah, could you say a little bit more about the types of abuses that service members faced prior to the CFPB?
Yeah, you know, when I was starting my career, my first big study showed that payday lenders were clustering around military bases, and we and my co-author and I proposed a national interest rate cap on loans to military service members. Eventually, that was implemented by Congress, a bipartisan bill that was signed into law by George W. Bush, and that's really made a big difference, and it's the CFPB that conducts the regular examinations and audits to make sure that payday lenders are not illegally targeting our military service members for triple-digit predatory loans. That's something that's a benefit to working service members and their families across America that I think we can all be proud of.
Do you believe that Congress was right to create the Office of Service Member Affairs within the CFPB?
Yeah, I do. It's a great office. You know, service members and veterans should have a say and should be able to be empowered and communicate with their government about financial services products that may not be working well for them, and also reflect back the kind of things that they need. That's the role of that office, and I think they're doing a good job.
And since Congress does not directly micromanage their budget through the appropriations process, are they in some sense triple insulated?
Well, I'd have to think about that. That's getting pretty meta, Dr. Foster. I'm not sure I understand what double insulated is, let alone triple insulated. So I think I have to take a pass on that one.
Okay, well, my time's nearly up and yield back.
Thank you, sir.
Gentleman yields. The gentleman from Florida, Mr. Posey, is now recognized for 5 minutes.
Thank you very much, Chairman Barr, for holding this hearing on the Consumer Financial Protection Bureau, one of the most beautifully sounding names of any federal agency, most especially for the most arrogant, petulant, and defiant federal agency of all times. I was really looking forward to questioning Mrs. Cackley of the Government Accountability Office, who is going to be a witness today. I'm sad that for whatever reason she's not here. I had most of my questions geared to her. I disagree with the professor that there's no evidence the CFPB has ever done anything wrong. I've been on this committee for 16 years, and I've witnessed their arrogant, petulant, defiant attitude and refusal to answer questions over the years. Mr. Johnson, it's my understanding that the GAO tests for CFPB compliance as generally accepted government auditing standards in their financial reporting and for contracts and grant agreements. Are you aware of whether or not this review seeks to ensure that money is being well spent, efficiently well spent, and that an adequate bidding process is involved?
Thank you, Congressman. My understanding is that the scope of the GAO audit is over the controls in place about financial reporting, not a review of the underlying spending decisions.
Okay. Mr. Johnson, Mr. White, do either of you know if the Comptroller General has ever been asked to provide an opinion of the constitutionality of the CFPB's funding?
I'm not aware, sir.
I'm not aware.
You know, given that the CFPB gets its money from the Federal Reserve that would otherwise end up in the U.S. Treasury, wouldn't it appear that it equates to drawing money from the Treasury without appropriations? I mean, just simple view of it.
It would, sir, with the wrinkle now that the Federal Reserve, as it unwinds its balance sheet, is taking quarterly operating losses. So the funds that it's providing to the CFPB, it's entering on its balance sheet as a deferred asset, which runs up the tab, so to speak, of future earnings the Fed will have to pay before it can even begin remitting surpluses to Treasury again.
Mr. White, has the CFPB in the past ever characterized its own funding as non-appropriated?
Repeatedly and from the very start, and as recently as last November in its 2023 annual financial report, in which the CFPB repeatedly referred to itself as an independent, non-appropriated bureau. These are in documents that they published after arguing the exact contrary to the Supreme Court. And I would just add, in a 2016 bid protest, the CFPB argued to the GAO specifically that the CFPB is not an appropriated agency, and therefore the GAO should not have any jurisdiction over the bid protest. The GAO agreed that the agency does not receive appropriations, but they still had jurisdiction. That decision was published by GAO in 2016. I've tried very hard through a FOIA request to GAO to get the CFPB's briefing arguing the opposite that it now argues to the Supreme Court, that the CFPB is not an appropriated agency, and I was not able to obtain that document through FOIA.
Wow, thank you. Do you know how the CFPB compares to the FTC's Bureau of Consumer Protection in terms of size and productivity, number of enforcement investigations, actions, or budget?
Congressman, my understanding is that CFPB has roughly double the budget, and over the past 2 years has filed roughly half of the enforcement actions, civil complaints or administrative complaints. The one difference in terms of the scope of FTC authority and CFPB authority would be that CFPB has supervision authority, whereas the FTC does not.
Thank you. I see my time's about to expire, Mr. Chairman. I yield back.
Gentleman yields. The gentlewoman from California, Ms. Waters, is now recognized.
This is a junk fees question. Thank you. Professor Patterson, thank you for being here with us, and I'm very pleased with President Biden's initiative to eliminate junk fees, as well as all the hard work of the Consumer Financial Protection Bureau under the leadership of Director Chopra to do their part in this initiative. This initiative has really resonated with Americans, with CFPB receiving more than 80,000 comments when they launched the initiative. To put this into perspective, House Republicans have held multiple hearings to attack the Basel III endgame proposal, which received only 400 comments, or 200 times less the amount of comments CFPB received on junk fees. Let's take credit card late fees, for example. Credit card companies typically charge consumers $32 for making a late payment. The CFPB recently finalized a rule that would generally lower these fees to just $8, ensuring that they are reasonable and proportional, as Congress required them to be in the Card Act. In doing so, CFPB will save $220 per year for more than 45 million people who pay these fees. This adds up to an annual savings of $10 billion for consumers. Instead of joining Democrats to applaud the move, House Republicans plan to soon advance a bill that would eliminate this important CFPB rule. Professor Peterson, my colleagues on the other side of the aisle have contended that CFPB lack legal authority for this rulemaking. Can you help us debunk this notion?
Well, thank you, Ranking Member Waters. The CARD Act from 2009 granted discretion and authority to the regulatory agency at the time, the Federal Reserve Board of Governors, to implement a safe harbor, and it sets out 4 different factors the Federal Reserve Board of Governors was supposed to evaluate in considering what that safe harbor fee amount would be. But at times gone by, there's additional data that's been gathered, and now the CFPB has, as it's required to do, revisited that regulation and made a decision about whether or not that safe harbor is set at the appropriate level. The Bureau has ample authority to revisit that and has come up with a number of studies that provide detailed information about what the total proportionate and reasonable costs are associated with late fees. So I believe that the CFPB is well within its legal authority to lower that safe harbor.
Thank you. Moving ahead, I understand you previously served not only at the CFPB, but also at the Department of Defense working on service member protections. How does CFPB's work to combat junk fees help service members, veterans, and their families? Will they be heard if Congress rescinds the credit card late fee rule?
Yes, they will, Ranking Member Waters. The Military Lending Act does not, under current implementing regulations, does not prevent overdraft fees from being imposed on service members, and it also doesn't impose late fees from being imposed on service members. So those are junk fees that our active duty military service members in the Army, the Navy, the Marines, all could potentially pay, and if the CFPB's implementing regulation is allowed to go forward, that'll be, there'll be cost savings that'll be passed on to our members serving.
Unfair question. Why would elected officials be opposed to their constituents, working people, be able to have a reduction in late fees? Why would any elected official on either side of the aisle be on the side of the big banks and corporations? That may be an unfair question, but I'm asking it anyway.
Well, Ranking Member Waters, it's a hard question for me to answer too. I think it's a really unpopular view. I mean, honestly, I don't know why you're going to bat for these late fees. I mean, you guys have something better to work on? Yeah, Chairman Barr, he's shaking his head at me. I think you got better things to do with your time, sir. Okay, all right. I think you're right, Ranking Member Waters. Let's let these restrictions on junk fees go forward. It's supported by the public. It's going to provide meaningful protection to the American people. It's a good idea.
Thank you so much for being here. I yield back the balance of my time.
I appreciate the professor's cheerful delivery. I do. I genuinely do. I like cheerful people. The gentleman from Texas, Mr. Williams, is now recognized for 5 minutes.
Thank you, Mr. Chairman, and I'm a small business owner in Texas. The CFPB's goal is to protect consumers from abusive financial practices, but like everything else the government does, the people they want to help, they actually hurt. But unlike most federal agencies, the CFPB was designed to operate outside of Congress' annual appropriations process. This is a dangerous practice that allows them to operate without any accountability or oversight from Congress, and the CFPB has a blank check budget and a director that acts as if there are no repercussions for his agency rules, and there's no way for a federal agency to operate at all. And without oversight, the CFPB can act as a partisan voice whose sole goal is to push the policy objectives and go on whatever misguided crusades they wish. The CFPB must be held accountable for the damage they are causing to financial institutions, their customers, and small business owners. Mr. White, could you elaborate on the dangers of having an agency with an unconstitutional leadership structure and unaccountable funding mechanism, and how does that hurt American consumers who are getting hurt in the end?
Well, our Constitution has elaborate procedures, not elaborate, but well thought out procedures for appointments and for funding of agencies, precisely because it is so important. Oftentimes personnel is policy, and oftentimes some of the most important decisions that Congress makes after it writes a law or amends a law is to decide who will administer that law under the president, and also how will that agency be funded. I am very much in favor of federal regulators keeping an eye out for and policing unfair, deceptive, or abusive acts and practices. But it's ultimately Congress's responsibility to monitor agencies' own unfair or deceptive acts and practices.
As we've seen, the CFPB's regulatory agenda has been a nonstop parade of partisan politics and wish list items from the Biden administration. The CFPB's crusade on junk fees, as they call it, the increase on burdensome small businesses reporting requirements, and UDAP authority are a few of the policies the agency is using to score political points, but significantly hurt consumers and business owners. Now, the CFPB's process of legislating via press releases has many institutions across the financial spectrum terrified of what confusing regulations could possibly be coming out of this agency next. The CFPB must follow all proper rulemaking channels and not use the policy statements or guidance to regulate. So, Mr. Johnson, can you expand on how the CFPB's practice of creating new regulations outside the proper process is ultimately harmful to consumers and small business?
Yes, sir. So all forms of agency guidance by law cannot be binding, but when the agency seeks to bind parties through guidance rather than going through the formal APA-required notice and comment process for rulemaking, it really warps expectations and creates uncertainty in the marketplace. That uncertainty pulls back on economic activity, and that harms consumers and producers alike.
Checks and balances are a vital function of our government to ensure accountability, and the funding structure of the CFPB lacks appropriate oversight and is vastly different from other federal banking agencies, as the CFPB relies on allocations from the Federal Reserve instead of from Congress. In order to have a check on the CFPB power, it's imperative that operations be subject to congressional appropriations, just like anything. So, Mr. White, if the courts determine the CFPB's funding mechanism is unconstitutional, do you believe the CFPB would be able to effectively operate under the regular appropriations process? And do you think a more transparent funding process would improve rulemaking by the CFPB?
Yes, sir. I believe the CFPB can operate perfectly well under the normal appropriations process, just as other financial regulators draw substantial funds from the appropriations process.
I don't think they can operate if they have to say in guidelines or rules. It's kind of pretty clear to all of us. And I can tell you, as a small business owner, the CFPB, the regulations is put on small business are unbelievable. And like I say, the very people they think they're helping, they're hurting. They're hurting consumers. They're raising costs, and they have no oversight. So it's something that we got to address. I leave my time back, Mr. Chairman. Thank you.
Gentleman yields back. Appreciate his leadership on the Small Business Committee. The gentleman from California, Mr. Sherman, is now recognized.
The CFPB is doing outstanding work. It's put $17.5 billion back in Americans' pockets. It's provided $4 billion to the Victims Relief Fund. It deals with 3,000 complaints it receives every day. Many members of the committee are well aware of those statistics. What you may not be aware of is that on November 8th of last year, it ordered Citibank to pay almost $26 million in fines for intentionally and illegally discriminating against Armenian Americans. And for those of you who do not have an Armenian American community in your district, it is particularly easy to discriminate against Armenian Americans because the vast majority of names end in IAN or YAN of the Armenian American community. But it's not just what was done with the $26 million or the $4 billion or the $17.5 billion. That's the tip of the iceberg, because when the CFPB acts, it deters bad actors from doing these things on a much larger scale. We're told that the CFPB doesn't testify enough. Their director comes before us at least twice a year, usually more often. We're told that the funding mechanism is constitutionally impaired. Professor, I think you did an excellent job explaining what it's not. But let me just address that. It is the same funding mechanism exactly that the Fed uses. And if the Supreme Court really wants to cause a tailspin for our economy and shake it to its fundamental roots, it would rule that the Fed is unconstitutional in some respect. I'm confident the Supreme Court will not do that. The existence of police does not mean that our citizenry is criminal, and the existence of a policing consumer transactions is not anti-capitalist propaganda. There is one piece of of legislation before us that's noticed for this hearing, and that is one HJRES 122, which is designed to invalidate the rule to reduce the charge for late credit card fees. Well, who amongst us has not sent in our payment late? And why should that fee be all they can get from us rather than something related to the bank's costs? Now, I remember when credit cards were embossed and carbonized paper was used, and the cost of processing transactions was high. Certainly, the bank can deal with the fact that a payment is late for $8, probably less. But focusing on that issue, Professor, 28 members joined in a letter I wrote dealing with the exact date. If the date that your credit card payment is due on April 30th, say, some banks say it's got to be in by 5 p.m. Eastern Time. Now, that makes sense if you're paying by mail, but so many people pay electronically. Is it fair to people who live in the Pacific time zone, let alone Hawaii or Alaska, for them to get statements that say, oh, you're on time if you get your money in by April 30th, and they get their money in electronically at 4 p.m. California time? These are banks that have hundreds of thousands of customers in my time zone, and yet somebody pays electronically at 4 p.m. on the due date, and they get hit with what is now a $36 fee, what under the CFPB rule would be an $8 fee. Shouldn't banks that operate with hundreds of thousands of cards in the West Coast time zone have their computers on past 5 p.m. East Coast time?
Well, Representative, I certainly agree with that. Our banks should be.
Oh, by the way, this applies to Utah. You're just one
I was thinking the exact
time
same
zone
thing.
over.
Yeah, that's right. Yeah, no, look, if there might be something in the contract that is some details in there where they use that as the predicate for allowing that as a matter of contract law, but it's not good policy. It's not neighborly of the bank. If you say that's the due date, you should get all the way up until midnight, and everybody in the country should be treated the same way.
I would agree for electronic payments. And back in the day when it was postal, one understands that there's only an afternoon mail delivery. But today, the computers can be on till midnight. I yield back.
Gentleman yields. The gentleman from Georgia, Mr. Loudermilk, the vice chairman of the subcommittee, is now recognized.
Well, thank you, Mr. Chairman, and I appreciate all of you being here today about this. Since the establishment of Dodd-Frank Act, the CFPB source of funding has been controversial at the least. Even now, the constitutionality of their funding is being considered by the Supreme Court, and I'm hopeful that the courts share our concerns that the Bureau's current funding structure limits Congress's ability to oversee the agency through regular appropriations, and obviously I'm a supporter of Chairman Barr's bill to do that. It's way past time that the Bureau is held accountable to the people and gets the funding it deserves through the regular appropriation cycle. With that, Mr. White, should the Supreme Court find that the Bureau's current funding structure is unconstitutional, or if Congress was to pass a funding mechanism for them, does the CFPB have a plan B, per se, to fund itself outside the annual appropriations process?
Thanks, Congressman. I must say I do not know what plans the CFPB is or is not making. But of course, it should be prepared for that eventuality, given that this issue has been litigated now for more than a decade.
All right, thank you. With the appropriate funding from Congress, is there any reason to believe that the CFPB wouldn't be able to fulfill its statutory mission? Yeah.
No, sir. The CFPB perfectly well can carry out its statutory mission. And if I may, a ruling against the CFPB's unique funding structure would not pose a threat to any other federal agency, including the Federal Reserve.
Is there any legitimate apolitical reason that the CFPB should be fearful of operating under congressional appropriation authority?
No, sir. And I think discussions like this, where members of Congress are touching on the substantive policies that the CFPB is reviewing, shows that members of Congress, just like the CFPB, can weigh these policy considerations just as much as an independently funded agency.
Okay, thank you. Last question, Mr. White. The CFPB and its supporters argue that having a single director makes the Bureau more efficient at helping consumers. Meanwhile, other federal financial regulators have multi-member boards or directorates. What makes the CFPB any different from the other financial regulators having a multi-member board would make them less effective?
Well, Congressman, I recall that when the CFPB was first proposed by then Professor Warren, she proposed that it should be a multi-member commission modeled after the Consumer Product Safety Commission. I think that the CFPB would do well as a multi-member commission, assuming that it was funded appropriately and actually did carry out its mission in the kind of, as the Supreme Court once said, quasi-legislative, quasi-judicial approach that befits a true non-political agency. But that's very much not the CFPB right now.
Is it your impression that by less effective, the Bureau's supporters mean less effective at pushing partisan regulatory agendas?
You know, I can't read the mind of the current CFPB, and I can't read the minds of its supporters either, but I do know that the CFPB right now is a very enthusiastic embodiment of a number of President Biden's priorities, and I'm sure people like that.
Well, thank you, Mr. White. And in the interest of efficiency, Mr. Chair, I'm going to give you back 1 minute and 40 seconds. I yield back.
Thank you for your efficiency. The gentleman from Texas, Mr. Green, is now recognized.
Thank you, Mr. Chairman. I thank the ranking member, and I thank the witnesses for appearing today. I had the preeminent privilege of being here when we had the '08 downturn, and it was a time of great turmoil. I recall banks not lending to each other. That's a powerful statement. When banks don't trust each other, wouldn't lend to each other. I recall how the consumers were being savaged. 327s and 228s, all sorts of products that were designed to give consumers an opportunity to fail. It was some difficult times. The Consumer Financial Protection Bureau didn't occur because someone just had a great idea. It came to fruition because there was a need beyond any that we could comprehend, and there had to be some means by which we could assure ourselves, to the extent that people can assure themselves, that this wouldn't happen again. Now, it's not perfect, but my guess is that if we didn't have it, we'd be trying to create it. It's just that important. It seems to me that the GAO's most recent annual audit is something worthy of consideration. Indicates here that they found that the CFPB's fiscal year 2023 financial statements were reliable and that controls over the financial reporting were effective. Goes on to say, the GAO also found that the Consumer Financial Protection Bureau's financial statements as of and for the fiscal year ended September 30, 2023 and 2022 are presented fairly in all material respects. No reportable non-compliance for fiscal year 2023. So there is an audit that seems to favor the entity being sound, fiscally responsible. I'm not sure I would like to see this Congress fund the CFPB. This Congress has difficulty maintaining leadership. This Congress has difficulty funding the federal government. Do we really want this Congress to fund the Consumer Financial Protection Bureau? So, Mr. Peterson, if Congress could not come to an accord such that we could fund the CFPB after some period of time, what would be the consequences of our failure to do our job?
Well, Representative Green, thank you so much. And you won't remember this, but back in 2008 when you were here, I got to testify before you back then as well. And you've always struck me as such a wise and decent man and full of compassion. And but to answer your question, if the Supreme Court or Congress strikes down the ability of the CFPB to gather its revenue through the Federal Reserve Board of Governors, and if Congress does not step forward and provide a source of funding, then we would expect eventually the Bureau's consumer protection tools would start to wither on the vine. We'd have fewer examiners that are conducting audits, fewer enforcement cases, less capability providing clarity and information for compliance concerns for businesses. So I think we would lose that protection that you all voted for back in 2010.
My suspicion is that at some point we would not have a CFPB, and that would suit the aims of many people. I support the CFPB. I believe we have to have an agency to look out for the people, and that's what it does. Thank you, Mr. Chairman. I yield back.
The gentleman yields. The gentleman from South Carolina, Mr. Timmons, is recognized.
Thank you, Mr. Chairman. I have grave concerns surrounding the CFPB's funding structure and really its operational accountability in general. The CFPB was designed to be shielded from any form of accountability, and the combination of legislative, executive, and judicial powers in one agency opens the door for gross misconduct with impunity. Under Director Chopra and the Biden administration, we've seen just that. A government agency weaponized to achieve political goals while forgetting its original charter to protect consumers. The current system of GAO audits is not enough to ensure there are proper checks and balances in place to rein in a rogue agency. Although the CFPB consistently is given a clean bill of financial health, I think there is much to be said about how little we truly know regarding the Bureau's balance sheet. It's essentially a trust us situation. I don't know about you, but I've come to distrust the CFPB's word. They tout their data privacy and cybersecurity measures, yet an employee was sending hundreds of thousands of tranches of consumer data to a personal cloud. But again, we should trust them to operate in a functional and fiscally responsible way despite the opaque veil they display. Mr. White, it is clear that in the modern administrative state, checks and balances have eroded as clearly as our separation of powers. What are the consequences of this erosion, and what steps can Congress take to restore the separation of powers at CFPB and better protect our citizens from a federal government that at times seems unmoored from the Constitution?
Well, thank you, Congressman. I see this delegation of perpetual funding authority to the CFPB to be part and parcel of Congress's broader, decades-long withdrawal from day-to-day lawmaking, much akin to its delegation of regulatory powers to any number of agencies. What you get is a different form of lawmaking, one that's less actually accountable to voters, one that's less moderated. It's unilateral because it's made swiftly by energetic agencies. If I may, a moment ago, Congressman Green pointed out very eloquently that the words of Dodd-Frank, its choices in its structure, these weren't just words, these weren't just ideas. I would say the exact same thing about the Appropriations Clause of our Constitution and our Constitution's clause for the raising of revenue. Those weren't just words, they weren't just abstract ideas, they were the hard-fought wisdom of the the hard-won wisdom of the founding generation. And our failure to live up to those rules today, I think, has had many, many bad consequences for the rule of law in government today.
Thank you for that. Switching gears for a moment, a few months ago, along with many of my colleagues, I authored a letter to the CFPB encouraging the Bureau to leverage their civil penalty fund to educate consumers on scams and fraud within the financial sector. Dodd-Frank states that the fund must first be used to compensate consumers who have been directly harmed by illicit financial activity. The CFPB then has the discretion to use the remaining balance for quote-unquote consumer education and financial literacy. In its annual financial report for fiscal year 2023, the Bureau noted that it made $0 in allocations for consumer education and financial literacy purposes. Mr. Johnson, given Congress's clear direction that the civil penalty fund be available for the purpose of consumer education and financial literacy programs, do you have any insight into why the civil penalty fund administrator has refused to allocate consumer education and financial literacy programs? And how do you believe a surplus in this fund can be best allocated?
Thank you, Congressman. I believe in the agency's history there have been two such allocations early in the agency's history to two separate financial literacy programs. The concerns raised at the time was that there were no controls or parameters over how, once obligated, the CFPB would use those funds. And a risk that those funds could be used to compensate outside groups who may be aligned with the agency's advocacy efforts. So to the extent that they are used, I think that the administrator, the CFPB, and Congress serving an oversight function should ensure that there are precise and firm controls around the use of those funds if they are diverted away from the victim compensation function.
Thank you for that. If a private business has a cybersecurity breach and an individual has damages associated with that breach, that private company is going to be sued and they're going to have to pay that individual for those damages. That's the civil court system. So when the government, the CFPB, damages hundreds of thousands of individuals, how is the CFPB going to make those people whole for the cybersecurity breach that they were damaged from?
Congressman, it's unclear to me. I think the CFPB has been less than transparent in all regards about what exactly happened.
They didn't even want to tell us it happened. I mean,
and what the resolution might ultimately be.
well, look, I mean, I think they have money in weird places. They ought to use that to pay damages to the individuals that they wronged because of their lax cybersecurity. Thank you, Mr. Chairman. I yield back.
The gentleman yields. The gentlewoman from Massachusetts, Ms. Presley, is now recognized.
Thank you, Mr. Chair. According to a recent poll, 82% of all voters, including 77% of all Republicans, support the Consumer Financial Protection Bureau and its mission to protect consumers. Let that sink in. More Republicans, let the record reflect, support the CFPB than support Donald Trump. And it's clear why. The CFPB, under Director Chopra's leadership, has taken decisive action to combat junk fees, hold predatory lenders accountable, protect seniors against fraud, hold big banks accountable, remove the burden of medical debt, ensure harmed consumers get the relief they need, and the list goes on. Now, while the CFPB's record speaks for itself, Republican members on this committee make it make sense, continue to show how out of touch they are with their own constituents as they launch attack after attack, willfully ignoring the broad support the CFPB has across the nation. This agency is dedicated to protecting consumers, and losing the Bureau would be disastrous for our financial system and economy. People are certainly entitled to their opinions, but not to their own version of the truth. And there is broad support that the CFPB has across the nation. And so willfully ignoring that will not change the truth. Professor Peterson, the primary attack from Republicans is about the CFPB's funding structure, but CFPB is not the only financial regulator with a source of independent funding. Do the Federal Reserve, FDIC, Office of the Comptroller of the Currency, National Credit Union Administration, and other agencies also have independent funding outside of the annual appropriations process?
Yes, Representative, they do.
Thank you. Now, the second attack from Republicans is that the CFPB is too good at protecting consumers. The CFPB recently finalized a rule to limit late fees that credit card companies could charge from $32 to $8. If this rule takes effect, consumers would save a staggering $10 billion, that's with a B, dollars annually. Despite this, Republicans are trying to overturn this rule. They're choosing to defend a deeply exploitive late fee practice that harms consumers at the expense of millions of workers and families who live paycheck to paycheck. Families that are struggling to make ends meet due to unlivable wages, a lack of affordable health care, the absence of paid leave, and many other policies that are pushing families farther to the margins. At their most financially vulnerable moments, these working families are charged predatory late fees by credit card companies. This is deeply unjust. Professor Peterson, can you elaborate on how the CFPB's late fee rule benefits everyday consumers, many of whom live paycheck to paycheck?
Sure, Representative. Look, when people can't make ends meet, they're likely to have a late payment on their credit card, and when they get socked with a fee, it's more money out of their bank account, less able to cover the cost, make sure their kids are getting enough to eat, making sure they can pay their rent. The CFPB's late fee rule, it's a simple rule. Decreases the safe harbor, makes it much more likely that banks are going to charge lower late fees, which means when people are really struggling to make ends meet, they're less likely to get hit with a high-cost fee. It's just better for the public.
Thank you. These Republican attacks against the Bureau are baseless. They do nothing to support or benefit the people, our shared constituents. The CFPB supports our most vulnerable and protects millions of consumers from exploitation, abuse, and predatory lending. We should be celebrating the Bureau and all of the staff for their hard work that often goes underappreciated instead of attacking them. Thank you, and I yield.
Gentlelady yields. The gentleman from South Carolina, Mr. Norman, is now recognized.
Thank you, Mr. Chairman. Mr. Johnson, would it be more disastrous, I guess, for the country to lose the CFPB as an agency, or to lose all of our credit cards, the ability for us to get credit cards?
I think one could argue that the lack of access to credit in a major consumer product vertical would be more detrimental to the U.S. economy and affect more consumers potentially.
Okay. The CFPB has tapped the Federal Reserve for $7 billion roughly, yet they've got $2 billion in cash on hand from the civil penalties, and it's just sitting there. What's that going to be used for, and why would it not be given back to pay the debt off or to help some of these victims that have been brutalized by the CFPB with legal fees and cost?
Congressman, part of the accounting recognizes the fact that the civil penalties paid pursuant to an enforcement action come in immediately, but there's a delay between the time it takes to identify a victim class and then allocate the funds. So some of the question about the unobligated balance in the fund relates to that timing effect, but one important consideration would be the amount of the unobligated balance that's not obligated to victim classes over the long term to understand whether or not those resources could be used for other purposes.
So it'll sit there unused for how long, would you say?
Funds collected in one enforcement action can be used through the civil penalty fund to be allocated to victims of other victim classes in future enforcement actions. So it would depend on the number of future enforcement actions and the potential remediation required in those classes, so it's very difficult to assess.
So who makes that call?
Ultimately, it's the director.
Chopra? It's totally up to him? I think the answer is yes.
The agency has discretion on how to obligate funds from the civil penalty fund for identified victim classes, yes.
Okay, on the credit card fees, and I support Chairman Barr's bill to undo I think, for the CFPB to get involved with banks that have to compete with other banks and to cut a fee from, if you don't pay the bill on time, I think it's an average of 12 to 15 days to pay a bill, from $32 to $8. If this extends to credit cards, should the next regulation of CFPB come to eliminating, if you don't pay your loan back or on your house or your car, is that burdensome to anybody?
Well, Congressman, I think one of the misnomers surrounding the credit card late fees rule is proponents are using a static analysis. So they're saying that if you just cut the size of a late fee assessed, that there will be an equivalent savings. Of course, we live in dynamic marketplaces where providers, consumers adapt to changed circumstances. And even in the Bureau's own analysis, it admitted that those who will pay costs as a consequence of this rule are those Americans who don't make late payments, and then other Americans who are maybe marginal credit risks, who may have lower credit balances associated with their cards, may lose access to their credit cards, may have to pay higher fees and credit interest rates as a consequence of the rule. So on a dynamic basis, there are significant consequences for many Americans, and by and large, more Americans will pay those costs than will benefit from the rule.
Or the banks will have to get a way to, I mean, they borrow money too.
they pay an interest rate on funds that they lend out on credit card users, and for the most part, a lot of them don't have the credit card. That's why the fee is higher, both on the debt, on the carried charges forward, and on the debt. Your agency is overstepping its bounds in so many different areas, and it's going to end up costing the consumers more in the long run than they are going to save. I yield back.
The gentleman from Wisconsin, Mr. Fitzgerald, is now recognized for 5 minutes.
Thank you, Mr. Chair. Unlike any other agency, CFPB's funding is protected by several layers of insulation, which was discussed a couple times here today. And as we know, CFPB directors required only to submit a letter to the Federal Reserve Board each quarter certifying the amount of funds that are reasonably necessary. We've had Jay Powell before the committee, sitting right where you are, and was asked a question specifically about the CFPB and what did he think about the funding and how did it work, and his answer was, they send us a bill and we pay it. The Federal Reserve, which itself is funded outside the appropriations process, has been discussed, through assessments on Federal Reserve banks, which are in turn largely funded by open market operations and not through appropriations process, as you know, then transfers the requested amount, which is capped at 12%. I would have loved to have been in the room when somebody sitting at the table dreaming this up said 12% of the Fed's total operating expenses is a good number. No rhyme or reason to it. By requiring Congress to appropriate funds before they can be used by the executive, the Constitution requires Congress to act first before the government can do anything. The current funding structure of the Bureau impermissibly reverses the process, right? It makes no sense. And by contrast, a handful of other agencies that are funded outside the typical appropriations process, like the FDIC and what's been discussed, NCUA, FHFA, they'll obtain their funding by assessing fees against what otherwise would be considered regulated entities, right? So there's a difference. But in each instance, the other financial regulators receive funding directly from regulated entities as authorized by statute. None of these agencies enjoy the perpetual funding mechanism, which funds drawn from another agency, let alone one with another layer of budgetary independence. So the Trump administration proposed limiting CFPB's mandatory funding in 2020 before providing discretionary appropriations in 2021. These changes were projected to provide over $5 billion in savings over 10 years. Mr. Johnson, can you elaborate on what sets the CFPB apart from other agencies in terms of accountability and discuss the increased accountability that could come from moving the CFPB to the congressional appropriations? I understand there's somewhat of a redundancy. This question has kind of been asked in many different forms, but if you could just, once again, take a crack at it.
Certainly, Congressman. So I think one key consideration for Congress to make is when agencies have siloed budgets, they don't make reasoned judgments about relative spending priorities for the U.S. government as a whole. That's a job that Congress has. And so when the agency goes through its own budget process, particularly if there's no congressional oversight, if there's no other external checks and balances, invariably the lack of oversight incentivizes loose spending and skews priorities. So the accountability that would come from congressional appropriations would be the collective judgment of Congress as a whole as to what the United States government's spending priorities should be and where the CFPB's funding fits within those relative priorities.
Mr. White, let me ask you, we've had Director Chopra before the committee numerous times as well. And the one thing that he's never able to, I think, address directly is, are there any reliable metrics available to evaluate the effectiveness of the CFPB in enforcing the federal consumer laws? And if so, can you please provide an example? But he's unable to answer this because really the way they measure success is to just kind of roll out data that says, here's how many contacts, here's how many phone calls we got. Well, if a member of Congress based their success as an elected official on how many phone calls come into the office, we'd be out of office soon. So can you just, once again, are there any real measurable, effective ways of saying, okay, the CFPB is doing a good job?
There have been efforts over 40 years to use tools like cost-benefit analysis to show the effectiveness of an agency's rulemaking actions, both the benefits but also the costs, both of which are important. But I think that your question illustrates the fact that especially in this area, in this agency, there's been a real paucity of metrics and a paucity of a commitment to finding metrics.
Thank you. I yield back.
The gentleman from California, Ms. Kim, is now recognized for 5 minutes.
Thank you, Chairman. I want to thank our witnesses for being here today. We're almost coming to an end. The Fed recently said it had a record loss in income of more than $114 billion. The CFPB is funded by earnings from the Federal Reserve System. Mr. Johnson, you mentioned earlier the operating loss, right? So how can we do that even with the operating loss? So can you elaborate on that a little more?
Yes, Congresswoman, it's essentially an accounting gimmick that the Fed uses. So rather than recognize that it is losing money and it has stopped remitting payment to Treasury from its surpluses, it's building up the amount of red ink from its losses on its balance sheet. And it's essentially a recognition that in the future, when it starts earning a surplus, it will have to pay off the accounting entry on its balance sheet. So, all dollars that are sent to CFPB now, while the Fed is losing money, run up the tab, so to speak, of future earnings that the Fed will have to realize in order to begin, again, sending surpluses back to the U.S. Treasury for purposes of deficit reduction.
Let me follow up on that. The Federal Reserve rubber stamps anything determined by the CFPB director to be reasonably necessary to carry out the authorities of the Bureau. Is there a legal definition or standard to help calculate what is reasonably necessary?
It's not defined in the Dodd-Frank Act, though I could point to an example or two of CFPB spending that is not reasonably necessary.
Okay, thank you. Let's move on to another matter. I'm a co-chair of the House Financial Literacy and Wealth Creation Caucus, and one of my priorities is to be able to enhance financial literacy in our communities. And then there is that CFPB, within CFPB's Civil Penalty Fund that was partially designed for the purpose of consumer education and financial literacy programs. And the total of all Civil Penalty Fund deposits was nearly $3.5 billion through the end of September 2023. So tell me, why does the CFPB not have something akin to the Fed's Compliance and Internal Control Office under their Division of Financial Management to ensure that Civil Penalties Fund is used for financial literacy programs? It probably was discussed earlier, but can you elaborate on that?
Thank you, Congressman. Again, if there are not identifiable victims in victim classes, there is a mechanism by which the CFPB could use a portion of those funds to obligate for certain programs. And they could be used. I think there are careful controls in place to make sure that the primary use and purpose of the fund to compensate victims can be satisfied. But to the extent there are surpluses, there is a penalty fund governance board within the CFPB that would be responsible for making those judgments about whether to allocate unobligated funds for that purpose.
Thank you. Mr. White, I have a question for you. We've seen how the CFPB has moved well beyond its legal boundaries and rapidly reinterpreted consumer financial law. So given the agency's design, are you surprised by any of this behavior?
No, Congresswoman, I'm not. And I would add that in addition to stretching the bounds of the substantive laws, the CFPB has shown itself very willing to stretch the bounds of the procedural laws to evade some of the basic requirements of the Administrative Procedure Act in trying to, in effect, make and impose policy without going through at least the notice and comment rulemaking process that could improve policy and make the agency more accountable.
Thank you. Can you also talk to me about some actions that Congress could take to reclaim power over this rogue agency?
Yes, Congresswoman. Well, as things currently stand, there's the Congressional Review Act under which Congress can review the major rules of any agency. So that is generally a good place to start. But second, as discussed, as I've brought up repeatedly today, Congress could reclaim its power of the purse regardless of what the Supreme Court does in the pending case. And then third, and perhaps just as importantly, well, definitely just as importantly, Congress should return to the original Dodd-Frank Act and put more specific substantive standards in the Act, at the very least, so that Congress is making the laws and not agencies.
Can agree with you more on that. So would it be acceptable for any other agency within the size, scope, and broad authority of the CFPB to share an IG with another agency? Mr. Johnson, you want to answer that?
Yes, Congresswoman. I think it's an artifact of the CFPB's creation, and it's tied, I think, to the CFPB's funding mechanism.
Thank you. I yield back.
Thank you. The gentleman from Tennessee, Mr. Ogles, is now recognized for 5 minutes.
To be or not to be, Mr. Chairman, I think that is one of the important questions. And if I could think of an agency that should not be, it would be the CFPB. The question was posed, do we have or don't we have better things to do with our time? And Mr. Chairman, I would point out that an agency whose funding mechanism is unconstitutional, I think that deserves our time. I think an agency that has gone beyond its mandate, that deserves our time. I think an agency that regulates and legislates by rule enforcement versus following the APA, the Administrative Procedure Act, I think that deserves our time. And so even though we may be getting into the minutia of some of these issues or some of these rules, they deserve our time. Most banks, credit unions, and independent community banks will tell you that one of the biggest issues for them is the CFPB. We've all seen the negative impact of practices like regulation by enforcement and other questionable agency actions. As we've heard today, the impact of this growing compliance burden from the CFPB is evident as the number of financial institutions continues to decline. Mr. White, in your 2022 Wall Street Journal article, you noted that James Madison emphasized in Federalist number 58, Congress's power of the purse was intended to be the powerful instrument preventing all the overgrown prerogatives of the other branches of the government. Please explain how this sentiment is applicable in the situation of the CFPB and what our founding fathers were warning us about.
Well, it's important that, thank you for your question, Congressman. It's crucial, and Madison recognized that it's crucial, that questions of the writing of laws, the spending of federal money, the collecting of federal money has to begin first and foremost with the part of government closest to the people, Congress, and in particular, the House of Representatives. And I just want to point out to this end that a decade ago when I was still in private practice, I helped to file the original constitutional challenge to the CFPB's funding and its executive independence. Our client was not a big bank. We talked to the big banks about the case. They were interested in the issue, but they did not want to challenge the regulators. It was a West Texas community banker who was willing to stick really stick his neck out and say, this is unconstitutional, and I want to take a stand. And I think that it's because the smaller banks and the regional banks have felt more than any other of their competitors the compliance burdens, the regulatory burdens, the way that technocratic rules are being imposed on community banking. And I think that also helps to explain, in part, the era of massive consolidation we're seeing at the community and regional banking levels.
Mr. Chairman, I want to point out, it's those community banks that are feeling the burden of the CFPB, that if you're Joe the plumber or you're the local mom and pop, it's the relationship that you have with the community bank. They're going to be your lender. It's not the big boys on the block, that have and they're feeling it too, quite frankly. But as you see the whittling down of the community bank, what it's doing to rural America, what it's doing to suburban America, enough is enough. The CFPB has unprecedented power and enforcement authority with nearly no accountability under its guaranteed funding mechanism. The CFPB estimated its funding at $717 million FY 2021, $734 million for FY 2022, $750.9 million in FY 2023. Is it sustainable to allow a rogue agency to continue down this kind of path? Please describe those dangers, Mr. White?
Well, it's not, and if anything, Congressman, the problem is only getting worse the more that the agency leans into some of the least accountable tools for policymaking, even further away from notice and comment rulemaking towards enforcement discretion, opaque supervisory authority. If anything, Congress needs to try to pose even more transparency and procedural regularity onto this agency, in addition to the other accountability measures that we've been discussing.
And to that point, is it fair to your small regional banks, or quite frankly, to any business, but you have this uncertainty in the regulatory regime, that suddenly you're afraid of the heavy hand of government because of a rule? Is that a realistic environment to be operating in?
No, not at all. It's hard enough for the community banks right now to compete, given some of the technological advantages and other just basic market competitive advantages that the bigger banks have. This is the worst possible time for agencies to impose even more disproportionate burdens of regulatory uncertainty on those competitors.
Mr. Chairman, I do have more questions. I'll submit those for the record. I yield back.
I'd like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witness for their response. I ask our witnesses to please respond as promptly as you are able. With that, this hearing is adjourned.